Welcome to a special live edition of The Friday Show. I'm Pollock Report Bloodstock editor Joe Nevels, joined today by editor-in-chief Natalie Voss and Bob Heleringer, an attorney and author of the book Equine Regulatory Law. That's right, he knows so much about the subject, he literally wrote the book on equine regulatory law. Bob, thanks for being on with us today.
Glad to be here. Thank you, Joe, Natalie.
So it was nearly 300 days from the time that the Kentucky Derby was run to the time when the Kentucky Horse Racing Commission put an official ruling out on Medina Spirit. His drug overage led to the horse being disqualified from the Kentucky Derby. Trainer Bob Baffert given a 90-day suspension, but we all know that's not the end of the story, or at least it's most likely not going to be the end of the story. We've gotten a lot. It's just beginning, folks. Yeah. So we've gotten a lot of reader questions, emails, social media, and we wanted to use this time to answer some of those questions, some of them sort of surface level, some of them a little more in the weeds. And Bob, we figured there was nobody better to address this than you.
I'm definitely a yard guy. I'm the weed. I hope none of the questions, God help us, have anything to do with where do I cash my tickets on Mandaloun.
We have gotten some of those.
There's a lawsuit. I want to check the license of that lawyer, okay, that is filing this class action suit. He doesn't want to claw back any money, but what is he telling these people? I mean, there's never been a case that has reopened an official race to change pari-mutuel payoffs. You can delete all of those questions if you have that. It's over, folks. If you tore up your Mandaloun tickets, they're still no good. Okay, don't go out to the infield 9 months later and try to look through the weeds you said the weeds. I think that's what you made reference to, and be looking for those tickets. They're no good.
Collector's items, great collector's items.
Unless they were to place, and then hopefully you cash that one. Okay, fire away.
So I know, Bob, you have a lot of opinions on sort of how each side has handled this case so far between Bob Baffert and the Kentucky Horse Racing Commission. So I guess, first of all, as an observer, what do you think of what you've seen so far? Does this follow the normal program? What's your impression?
Let me tell the listeners, is that what they are, listeners or viewers?
Both,
viewers, that my degrees were in American history and law. Okay, they weren't in public relations, but even I know that a press release impugning the integrity of every member of the Kentucky Horse Racing Commission, impugning the integrity of one of the stewards who has the nerve to work at another racetrack that Churchill Downs owns, and ipso facto, therefore he's biased, is just so unprofessional. It's so insulting to everybody in racing, everybody that's certainly a racing official. And Mr. Clark Brewster, who made those allegations, he did his client a huge disservice, okay? He did the rest of his legal team a huge disservice, and he ought to be bounced off the legal team, okay? Craig Robertson, the other, I assume, the primary counsel for Mr. Baffert, is as good as there is. He's a throwback to Ned Bonney. I mean, he knows the science, he knows the racing, he knows the law. And to have his partner engage in this kind of unprofessional conduct is just going to really hurt their case. And boy, you don't want to, you got enough problem with the facts, with the law. I mean, why create additional problems for yourself? So I just wanted to say something for the integrity. They don't have a forum like this guy does. And they're too decent to speak out. I know a lot of them. And I was one myself back in the Warren Harding administration, but I would have been extremely offended if I was around back then and somebody said that about me, especially since it has not a scintilla of truth. So I just want to say something for the integrity of racing officials that do a great job every day. They make sure our game is honest, and they don't get paid a whole lot of money. They have a lot of away from their families on weekends and holidays, and I think they're wonderful people. And I have a lot of fond memories of the days when I was one, and it's just I just can't believe somebody would stoop to that right at the get-go. I mean, say you disagree, say you can't wait to put your evidence on and be aggressive and represent your client. I'm totally for that. I've got cases right now against the Horse Racing Commission here in Kentucky, and I'm going to battle them. Okay. But it's just, you don't go as far as he did. Okay. That's my Stephen A. Smith moment. Okay.
Well,
They have no answer for LeBron. They have none. The Cavaliers do not deserve to get LeBron, whatever.
So here's the thing. I've got a follow-up question for that. And it is kind of based on Dream Team. So we're gonna stay on the LeBron thread here. Okay. Baffert is being represented by two major attorneys here, Brewster and Robertson.
One major attorney.
One.
Yeah.
Well, two, but there's sort of two spearheading ones. What is sort of the strategy behind having a team of attorneys in a case like this? Why would you hire two separate?
No, I mean, why not 20? I mean, when maximum security was disqualified, I mean, did you see that legal team that the West had? I mean, my God, it was almost me, by the way, but then they sobered up. But Karen Murphy and Dennis Drazen, they had a big firm out of Lexington. He's going to kill me because I'm not thinking of his name right now, but really he led the way. And Mark Twain said one time, if you got two attorneys that agree, one of them's unnecessary. But the more, I guess, collective intelligence and skill and thought, the better. But I mean, you can't get any better than Craig and his law firm. So, but that's up to them.
But it's not. I would think it's, if you have that many voices in the room, it might end up being like a too many cooks situation. What is the benefit of not having like a sort of a unified voice when you're trying to stage
and believe me, there's no unified legal bill. They'll all be sending those in. So
I'm sure.
I don't know. You'd have to ask them, but I guess the more the better, and everybody can pool their thought. I mean, when Peter Fuller in the '68 Derby, he had a team, Ned Bonney and Arthur Grafton. They had another fella in there I'm not thinking of, but the Racing Commission had their own counsel, and then they had outside counsel. So, it's the Kentucky Derby. They're going to have as vaunted a legal team as they can on both sides. I don't know if the commission is going to go out and hire an outside firm. They've got general counsel Jennifer Wolsing, who's, I know she told me she's watching, so she's very good, guys. Look out. I mean, she's very dogged. I think I've seen that adjective applied to her, and they're good. She's got a team over there, and they may get outside help. So it's going to be a battle, no question about it.
So, Bob, I know that you're not representing the commission in any way. You're just sort of speaking from your experience, obviously, here. But since they have not really been able to issue any kind of comment on this case, obviously, as we've been waiting for the Stewart's ruling, many of us have asked at different times for information or updates or like what's going on, and everyone's kind of gotten the standard line of like, yeah, we can't discuss active cases. Why do commissions in general, because I know Kentucky's not alone in this, why do commissions kind of have this policy of just being as quiet as they can and not really wanting to tell their side? Because this feels like a very two-sided situation, right, but one side's not been able to talk. So why is that?
Well, it's very obvious. I mean, there aren't circuit judges sitting around giving interviews about the cases that they're presiding over, even when they're over. It's extremely unusual to hear or see a judge comment about a ruling they make or a decision. So here, our racing commission, like any racing commission, is going to sit in judgment of any appeal. And if they've been out holding forth about what they think as individuals or collectively as a commission, they stand the risk of being asked to recuse themselves by the attorneys for the fellow doing the appealing. So it's frustrating for you media people, I know, to be kind of unable to communicate directly and thereby make a living. But that's the reason they can't do it. I doubt if this commission is going to hear an appeal themselves like the Peter Fuller Commission did. God help those 5 guys. They sat through 3 weeks of, I believe the adjective is mind-numbing testimony about the finer points of chemistry. And they were all somewhat delusional after that and swore it would never happen again. So now they farm it out to hearing officers for the most part. And then the commission will look at that report. I'm guessing here, unless 19 people can set aside 3 or 4 weeks of their lives to hear all this. I just don't think that's going to happen. But eventually they will make the ultimate decision on any appeal. And they've got to be remain objective and wait for all the evidence to come in, because they hear it de novo, as it's called. That means all over again. No matter what the stewards did, you get an open, original shot at the commission level. And so they will make the ultimate call.
So you just sort of outlined the first step in the appeals process. We've had a number of people ask, like, okay, so where does this go from here? It sounds like either a hearing officer or the full commission. What happens after that, assuming that if this next level upholds what the stewards have decided and Baffert decides to continue appeal, or Zidane decides to continue appealing? What do the steps look like after that, and how far can it go?
I don't think we've ever had a case, I'm trying to think, where the commission reversed a steward's decision. That's never happened in Kentucky to my knowledge. And it has happened in other states. It's in my next book, which is coming out this year, by the way, the second edition. I know people can't wait. But anyway, from there, it goes to the judicial review process. It'll be heard by one of the 2 judges in Franklin County. Now, they, again, at that point, though, there's no do-over. Okay, the judge is just going to look at the record. Judge Miggs in the Dancer's Image case looked at 14 volumes of testimony, and I've seen those volumes. They're pretty thick. You can make some big volumes if the case takes 3 weeks, and it did. And so it took him 2 years to wade through all that, and they had other hearings and arguments, but before he issued his decision that reversed the Racing Commission, by the way. So even with just reviewing the record, if the judge feels like what the commission did is not based on, quote, substantial evidence, and boy, there's a term of art, then they have grounds to reverse the Racing Commission or any administrative agency. They can reverse it. So that's what Mr. Baffert, I'm sure, and his legal team are banking on to make as good a record as possible before the commission, as favorable a record as they can, and get in all the evidence they can, and then take a whack at whoever gets it in Franklin Circuit Court, either Judge Wingate or Judge Shepard, and say, ask them both to put on their Judge Miggs to channel him and say, hey, there's not enough substantial evidence here, reverse it. Of course, then it would go up to the Court of Appeals. It would probably bypass them and go up to the Supreme Court. But
the state Supreme Court, you mean?
Kentucky Supreme Court.
Kentucky Supreme Court. Gotcha.
Well, the U.S. Supreme Court's a little busy these days, but we would go up. Yes. There's no real federal issue in here. Now, again, I don't think anybody's going to try anything in federal court like the West did. We know how that turned out. So I think this will go primarily through state court, exclusively through state court. Where at least they're going to get a hearing. Okay. The West never got a hearing. And that was significant, but you don't get that automatically in federal court. The first thing any defendant does in a federal case is move to dismiss for failure to state a claim upon which relief can be granted. And federal judges love to get rid of stuff. I mean, they just use that Rule 12B. They go to town on that. But here in state court, they're going to get a hearing. Both of these judges are experts in administrative law, and they're very fair, both of them, very objective. They have reversed the committee. I mean, Judge Wingate declared unconstitutional the absolute insurer rule about 3-4 years ago. Now that got reversed on appeal, but these are both judges who have reversed the commission a number of times. They've upheld them also, and even more frequently, but still, it's not a rubber stamp situation by far. Okay.
So let's talk about the ruling that we have in front of us right now. 90 days. I believe Baffert got $7,500 fine. Some of the questions we got was, why was the fine so low? And why is the suspension so long? Can you go into the details of what got us to that point?
I'm not an expert on this punishment scale they have now. Most racing commissions have, I think the ARCI came up with it. It has a, I've compared it, nobody's going to like this on the other side, but I've compared it to the persistent felony offender law, where if you have a record, and unfortunately for Mr. Baffert, he has a record. And so any licensee that has had previous offenses, previous sanctions, is going to get an increase in fine, increase in suspension. They're not going to have as much access to mitigating circumstances and that kind of thing. So I can't explain the specific dollar amount or the specific amount of suspension, but I know there's the scale that they go by, and it applies to him as well as anybody else. He doesn't have, despite what the public might think, he doesn't have his own rules of racing and regulations and statutes and penalty schemes. They apply to him. Or as the commission, or as the steward's ruling referred to him as Robert A. Baffert. I didn't know. I thought he was baptized Bob Baffert. I didn't know Robert A. Baffert.
You learn something new every day.
Like for the viewers, I'm Robert L. Heleringer. So there you go.
So one question that we got from a reader, actually, I think we got it a couple times, which I thought was kind of interesting. Why did the commission in this case, or in general, not issue a ruling against the veterinarian who prescribed the medication that they're saying triggered the positive?
Well, I'm not sure he did anything wrong. You'll have to ask the commission that, but even Dancer's Image, when he got butazolidine, that was a legal medication. It just couldn't be in their system when they race. Okay, there's nothing wrong with the medication that Medina Spirit got. It was when it was found that has come a cropper of the rules. So I don't know that the veterinarian did anything wrong. I mean, there was, if you go back and look at, I keep going back to the 68 Derby, but I mean, there was all this drama over Alex Harthill and, did he inject the horse? And he was treating the horse, and the drama and the mystery was when he did it, which he went to his grave, never really being clear about that. But it doesn't matter. He wasn't injecting the horse then, or the people treating Medina Spirit were with anything illegal. I mean, this isn't a case of some sedative being, an attempt to drug a horse to affect the outcome of a race. Far from it. It was a medicinal, therapeutic substance, and it can't be in their system on race day. So that's the problem.
Mm-hmm. And that kind of leads into what we have. We have a reader question. If we can throw that up on the board. Ray Pollock. I've heard of the guy. Yes.
Ray who?
I know, right? He asked, does it matter how the betamethasone got into the horse's system? Obviously, a big argument for the Baffert and Medina Spirit team was it was a cream, it was a therapeutic, so therefore, it's not like anything nefarious was happening here, but he's still popular.
Well, this for Mr. Pollock, just a nondescript viewer. Sure, that's going to be their whole case, and they're going to hope that the judge ultimately, probably not the commission, but the judge will agree with them. This follows the line of a lot of defense attorneys here in recent years are talking about environmental contamination. If you remember, was it this case? Baffert's had so many, but there's one where the assistant, what's his name?
Oh, Jimmy Barnes with
the
cases in Arkansas.
The lidocaine patch, and it got into the feed, and then they've tried to argue that their infinitesimal little amounts that were detected could not affect the outcome of the race. Not affecting the outcome of the race has almost never worked, but it keeps being raised as the amounts detected decrease. That justification or explanation rises in importance if you're a defense attorney, but the regulation is pretty explicit. It can't be in there at all. It doesn't differentiate from what source. So, you got a problem. But as an attorney, you take on the problems and you deal with them, and you don't just throw in the towel. Well, sorry, we can't. We have no defense. Quite to the contrary. They're going to defend their client, and they're going to do it aggressively, as they already have. I mean, Craig Robertson went to great length to have this substance broken down, and I almost failed chemistry in high school, but I mean, to where it came from, and maybe Craig did too, but he knew where to send it. And this was a great stroke for him. It gave them at least a chance, okay, in the court of both public opinion and in the court that really matters, which is Franklin Circuit Court, that they might have a chance to overturn this.
So you mentioned Jimmy Barnes, and I want to sort of keep on that thread for a little while. Assuming the suspensions goes through, Baffert gets his 90 days. What keeps him from transferring his horses to Jimmy, either as an assistant trainer or if he went out and got his own license? And, we've had people wonder about his Derby trail runners this year. If something happens pretty immediately, he takes his medicine, he takes the 90 days. How do the horses get distributed from there, and who is definitely on the no list?
Yeah, I don't know. Well, Mr. Barnes would be, I think, and I if stewards are watching this, they can chime in and correct me. But if it's Mr. Barnes still working for Bob Baffert, then they couldn't do that. They would have to transfer the horses to somebody out of that barn. And if Barnes took out his own license as a trainer, I guess that would be okay, depending on what state you're in.
Right. Don't
have Heise yet, the great savior that's going to uniform all this stuff. Can't wait for that. It's another show, isn't it? Heise. Wow.
Yeah, that's I remember it was the Breeders' Cup the year that Jerry Hollendorfer was kind of ruled off for a while, or not allowed to race, and there was horses that were running for one of his assistants, but they had the big H on the face mask because it was clearly a Hollendorfer horse. We all knew this.
Maybe that guy's name was Hughes. You never know. I mean, it could have been his own, or Heleringer.
Yeah, I mean,
could have been another guy. But the stewards are really usually they scrutinize that pretty closely. I mean, it's got to be would have to be somebody else, I would think, while you're suspended.
You mentioned the testing process that Baffert's legal team sort of put the remainder of the sample through. And I had, as we were waiting for the ruling to happen, I had a lot of people ask me, like, why is the commission kind of indulging them and holding off the hearing process before the stewards for this testing to get completed if it's a letter of the law issue and it's not going to matter for the stewards' purposes how the drug got in the system anyway. I wondered, just as my own personal theory, I haven't talked to anybody at the commission about this because they can't talk to me, but I wondered how much the motion case might have had to do with the commission feeling like we have to allow somebody the chance to build a defense. We can't just sort of cut it off and say, no, you're done. We don't want to listen to you. We're just going to make a ruling. What are your thoughts on why they sort of appear to indulge them?
I know, Natalie, you've said about 3 times they wouldn't talk to me. I mean,
I don't blame them. I'm just saying that I don't have their perspective myself because they're stuck,
Nothing personal. I'm sure they like you very much.
Oh, no, I understand that. That. I'm just trying to say I can't represent what they're saying because they're not able to say that to me.
Well, no, they if they were to say something like, no, we've got enough, we're going to have a hearing, we're going to do what we want to do, that opens up a tremendous due process claim, okay, that you didn't give us an opportunity to mount a defense. And that's another outgrowth. I know I keep coming back to the Peter Fuller case, but Horstman had basically no rights back in those days. The commissions and the stewards ruled with an iron hand. And the Peter Fuller case, despite him losing it, all of these reforms came out of it, not the least of which was an improving of the methodologies and scientific testing, which the Fuller defense team, Ned Bonney absolutely destroyed Kenneth Smith over 3 weeks, to the point where the judge tossed it, said, those chemical tests were worthless. And so the industry learned from that. And another outgrowth of that was that Horstman had rights, and the split samples came out of that. And the due process arguments came. Of course, the Supreme Court even weighed in, the U.S. Supreme Court, the Berry versus Barchi case. You have a property interest in your license. You have due process with your license. So all of those things. And the commission is going to give a licensee every opportunity to make their case, and within reason. And so, yes, it took a long time, as your last viewer wrote on about a weekly basis about how long it was taking, and it did. But they wanted to make sure they gave the Baffert team every opportunity to assemble their case and their evidence. And I think they did the right thing in doing that.
So the Baffert team is fighting a battle on many fronts, as we know. We have the KHRC, we have the stuff with Churchill Downs, NYRA. There are a lot of different organizations that are trying to, get him ruled off or, otherwise punish him. How does what we're seeing...
Then there's others that are welcoming him.
Yes.
I mean, last year they rolled out the red carpet. I think they met him at the airport with a limo. I mean, he's also still popular in some jurisdictions.
Oh, absolutely. What I'm curious is, now that we have someone that's put down a formal ruling, the KHRC, how does this affect how the cases go with the Churchill Downs 2-year suspension, the stuff going on with NYRA right now, with that sort of battle going on? Is this something that can be applied to that, or are those completely separate issues that will have completely separate arguments?
I think they're mostly separate. Your ejection cases are totally distinct and different from a drug positive. There's still due process elements in both. And again, it depends on what state you're in. God, I hate to say that, but it really is the truth. In West Virginia, a state, their Supreme Court said a track had no authority, basically, to eject a permit holder. That's what they're called. Only the commission could do that. Okay. And so, and then you had 50 years ago, a federal court say that a racetrack has an inherent right to let in who they want, to eject who they want, for any grounds except what they call constitutional ground. You can't eject somebody because they're Catholic or they're Jewish, or they can't say women can't come in, whatever. And other than that, their rights are pretty broad, but they're not nearly as expansive as they used to be. So, Baffert won the first round in New York, where they didn't even give him a hearing, and the federal judge just read the riot act to NYRA. I mean, if you read that opinion, she lectured him pretty good on due process, and Berry versus Barchi's in there about every other paragraph, which apparently nobody had read, the NYRA team. So now they gave him his hearing, and probably going to come up with the same edict that they did last year. But those are different. They haven't challenged Churchill Downs yet, their ban. They keep saying they might, or that they will, but it hasn't been done yet. And it'll be a whole different set of case law. I'm familiar with a case. Oh, what was his name? Luther James, that got thrown out. He was a gambler, a bookmaker, and this is back in the 80s. You don't need a book today, you bet online. But he was ejected from Churchill Downs, and our Court of Appeals upheld the lower court not giving Luther James an injunction to come in. And our Court of Appeals wrote this expansive opinion on what the rights that Churchill Downs had. Private property, even though it's closely regulated, it's still private property. They could do what they want. They could declare a guy undesirable. But now that was in the 80s. And, we had some intervening decades. So I think that you got more of a shot today to overturn something like that, depending on where you are. In Kentucky, I'm not sure. Churchill Downs will come into that arena with a pretty strong hand. It's their derby. It's private property. You don't have a constitutional right to run in it. I mean, you really don't until someone says so. All these cases I've read where people have sued recently, claiming, including the West 2 years ago, that, they have a constitutional right to the purse or a part of it. And federal courts have just thrown that right out. They can't find one in the Constitution, whether they're an Obama judge or a Trump judge. They now they put in the press these poor federal judges. They label them. Well, he's a Bush judge. Oh, okay. What does that mean? I mean, once they're on there, somebody might want to read the Constitution. Federal judges are on for life. They could be anybody they want. And as long as they don't rob a bank, they got that job as long as they live. As Thurgood Marshall said famously, they asked him when he was going to retire. He said, well, I was appointed for life and I'm going to serve out my term. And he almost did.
That works.
Yeah.
So I am curious, one thing with Churchill Downs Incorporated in particular, I believe that their ban was not just for the Kentucky tracks, but for all CDI properties, which obviously spans over multiple states. Does that make it a different quagmire that they could go fight at, fairgrounds in Louisiana?
Well,
or go
sure.
fight at...
I mean, on the slight chance that they might move the Derby to Turfway Park, they make the ban all inclusive for any of their properties. I mean, it would look a little inconsistent if they let him run in the what's the Derby prep now called a Turfway?
The Jeff Ruby Stakes.
The Jeff Ruby. Thank you.
S-E-E-A-K-S.
It's had very many variations. The furniture.com case, the Jim Beam. I worked in the mutual department when it was the Spiral Stakes. I don't know where they came up with the Spiral, but they should have just named it after John Battaglia and let it go. Now his race is a prep for that, but one of the greatest guys in racing that ever lived, John Battaglia, Mike's father, gave me my first job at Miles Park, and they should have named the race just for him and be done with all these, looking for somebody every year. It's like the Corn Ferry Tour on the pro golf. They used to be, that had all kind of names too, none of which I can remember. But the junior league of the golfers, they kept switching sponsors, I guess. I know this is all fascinating. You're just spellbound, both of you. and everyone at home is turning it off. What is he talking about? I mean, if you need some fill here, I'll go through my Stephen A. Smith page again.
Well, Natalie, you got anything else on your list?
No, I think we've actually gone through most of what people have asked us. I'm just looking back at the list, but I think
somebody wrote it. The Ben Hogan Tour, the Nike Tour, the Web.com tour, Nationwide Tour. Wow. JD Fox must be a golfer. That's all I can say, but he just came up with all of them. Wow. I don't even know what Corn Ferry is. Mr. Fox, do you know what that is? The Corn Ferry Tour. Korn, not the vegetable. But anyway, they're the sponsor of it now, and they're going to be thrilled to hear me questioning what they are, I'm sure.
This is how people find out.
We spend all this money, and this Heleringer guy has never heard of us. Corn carrot. Maybe they
Well,
sell insurance.
Well, we'll get that answer offline. Before we sign off for the day, Bob, do you have any other thoughts you want to share with folks? Anything on any of the volleying legal things that are going on right now?
No, I've about exhausted my complete repertoire here today. I'm ready for lunch. This show did lunch, didn't it?
Same here. Let's
be here any minute.
Well, let's go get some lunch. Bob, thank you so much for being on today.
The only guy that could do better than this is Drew Malika. You got to have him on one of these shows, okay? Because he's really entertaining. And, he's a street lawyer too. Yeah. Did you know that? He's a street lawyer.
A street lawyer.
But he's a good street lawyer. I don't know. He calls judges names, I think. That's what a street lawyer is. But Drew's a great guy. Mm-hmm. Anyway, good being with you all.
Yeah, thank you so much. And thank you all for watching this edition of the Friday Show, a live edition. If you're watching this on YouTube, don't forget to like, share, and subscribe. Get the word out so more people can watch, ask questions. We love doing these. And we will see you next time on the Friday Show.